evening, everybody. Welcome to the, oh geez, what day is it? November the 18th? Sorry, 19th. Oh, I made it through a full day of work and not knowing the date. That's probably not good. Welcome to the November 19th Zoning Board of Appeals hearing. I'm just going to go through and introduce the board. To my left, from your view, is the Vice Chairman of the board, Ken Foreman. To my left is TJ Hurry. He is the clerk of the board. To TJ's left is Ed Van Kuren. He's a voting member of the board. And to Ed's left is Paul Murphy, who's also a voting member of the board. Sri Budrow is our zoning administrator. Mark Bobrowski is here. He is special counsel to the Zoning Board of Appeals on these matters. Andrade Guy-Shecker is our recording secretary. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considering requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. Decisions are made through the public hearing process, which we'll all be participating in tonight. Our goal is to hear testimony from the applicants and the public and allow full and fair discussion to the project prior to rendering a decision. The three matters that are on tonight have already been open to the public. We've already had some testimony, and we're going to be, I believe, trying to wrap up at least two of those and continue on with the town's special permit application. Public comments should be directed only at the project and only at the application that's before us. So obviously we have two different matters here, and if you're going to be making public comments, you should be directing the specific applications that are before the board. And we're going to, since there's so many people here, be very strict with our 2-minute rule. So if you have comments to give from the public, please adhere to the 2 minutes rule, and if not, I'll be reminding you gently. So with that, we're going to be taking the appeals first, I believe, so I would need...
Okay, I would like to move then that we take 6815, the 154 Blacksmith Shop Road appeal of wind turbine 1 and 2 out of order.
And the other
Run
ones?
both.
Please.
And also followed by 70-15 Okagawa, also 154 Blacksmith Road. Shop Road wind 2 appeal.
Is there a second on that?
I'll second that.
Okay, so that was Ken and TJ. All those in favor?
Aye.
Aye.
And I.
Great. So the modified procedure, I believe, is Attorney Tillotson. Are you speaking first?
No.
No?
I think what we agreed
I
to
apologize.
was Attorney Senni and Attorney Watt.
Okay.
And then their clients would.
Okay.
And I don't want to speak out of turn, but I think that's what we had discussed. Would each be given 2 minutes if they chose, and then I would speak, and then you would open it to the public.
Okay.
Thanks.
Thank you. Thank you for the explanation, too. Attorney Watt?
Thank you, Alexander Watt, for Neil and Elizabeth Anderson. Probably won't even use my 5 minutes. I think you've probably heard everything before. Just a couple of things. Again, on Wind 1, I think your prior elder appeal controls in that, and I believe that you should just simply echo that and issue a cease and desist order with respect to Wind 1. On the Wind 2 aspect of the appeal...
Oh, excuse me, if I can just stop you, too. If anybody's recording this meeting, I just need them to identify themselves prior to. Okay, so I have two. So, sir?
John Carlton Cross,
And could you just provide your address for the record?
80 Church Street, Winslow.
Okay, thank you. And I believe I saw another hand.
Lynn O'Brien from the Enterprise.
Okay, thank you. And Attorney Watt, I'll return it to you. And I had some hands in the air, so if you could speak up as well, that would be great.
Thank you.
Thank you.
Okay, so again, with respect to Wind 2, now the town in their memorandum of 1111 does concede there was no actual notice to the Andersons of the issuance of the building permit. So the question, at least with respect to the 30-day period, is whether the Andersons were on a duty of inquiry. Now, the town has also stressed in its memorandum that Wind 2 and Win 1 are distinctly separate projects. So it suggests to you that simply the fact that the Andersons knew Win 1 was up in no way places any duty of inquiry with respect to Win 2. Again, just briefly with respect to this idea that Win 2 was generally well known, that there had been notice through public hearings or through town meeting votes or through announcements of contracts is all well and good, but the town, in order to show that they had a duty of inquiry as a result of their notices, have to show that the Andersons actually had those notices. There's nothing to show that the Andersons had that notice, and I believe in their affidavit they indicated that there was no notice. So that's with respect to the 30-day rule. Now, the main thrust of the town's argument here really falls on what is called latches. And latches is an equitable remedy. I'm sure your counsel would tell you that it is what is called an equitable remedy. And what it is an unjustified, unreasonable delay working to the detriment of the landowner. Now, I don't think any of the cases really are going to be helpful to you in this area. All those cases dealt with a single project, a single permit or a single entity. This is distinctly different. Win 1 and Win 2 are identical in terms of their zoning posture. Win 1 has been determined to require a special permit. Win 2, likewise, would require a special permit under the zoning bylaw. In August of 2010, Win 1 was the only turbine that was up and operating. And the Andersons began their appeal process at that time by filing a request for enforcement with the town building commissioner. So the town had knowledge at that time that there was I don't know how they viewed it, but it was a significant challenge, as was borne out ultimately by the appeals court that determined that a special permit was required. Irrespective of that, the town voluntarily decided to proceed with its plans for Win 2, its investments, its building, and any harm that the town suffered was self-inflicted. If one wants equity, one seeks equity, one must do equity. And I would suggest to you that there's no showing here that the town has acted equitably. Just one last thing. And I don't want to get into the disclosure of confidential discussions too much now. But the town indicates that the town was using that not to prove the truth of the matter, but to impeach the Andersons as to whether they were really suffering harm. Whether they really were suffering harm, because really, wouldn't they have moved away if they were suffering harm? Well, the Andersons have lived at that property for 25 years. They built it. There was no wind turbine at the time there. And to simply suggest that, well, if you were bothered by it, you should move away, just seems disingenuous. And that's really all I have to say. I'll answer questions later.
Thank you.
I don't know if Neil wants to speak now.
Attorney Sunny.
Good evening, members of the board, Madam Chair. My name is Christopher Senni, and on this matter, I represent only 3 Falmouth residents, Barry and Diane Funfar, who are out of town, but their daughter Christy is here and hopes to speak during the period of time when our clients are given 2 minutes. and Linda Okagawa, who is here this evening and would also like to address the board. I'd also like to just talk about the documents in front of you for a second. You have several documents that have a bearing on the Okagawa appeal. I call it the Okagawa appeal, but it's Okagawa and Funfar making a fresh enforcement request after the Supreme Judicial Court ruled that it wouldn't grant further appellate review of the appeals court decision. What you have in front of you is a presentation by the town of Falmouth, which you obtained the last time we met, October 29th. I have written a legal memorandum dated October 28th, the day before the last time we met. Attorney Tillotson for the town has provided a memo dated November 13th, and the original application or appeal from the action of Eladio Gore is also in the file. What I haven't put into this file yet is the PowerPoint presentation I made on September 17th to this board in connection with Win 1. And I would like the record to reflect that I'd like to incorporate that into this record. So the June 8th request to Eladio Gore reads, the appeals court decision applies equally to Win 2. And in that document it states, no building or structure shall be erected and no premises shall be used except as provided in the district use regulations. Now Win 2 is a structure that was erected not in conformance with the district use regulations because, as we now know, it required a special permit. Mr. Gore responded by saying, I'm not going to act because no court has made a decision with regard to Win 2. We had a court decision with regard to Win 1, but not 2. And in the appeal, where I brought an appeal of Mr. Gore's decision to your board, I wrote, Win 1 and Win 2 are part of a single wind energy program the town launched at its wastewater treatment facility. The town should seek one special permit or two as part of one special permit application. Now, the reason I raise this is that I think there's a little bit of lack of clarity as to whether or not the Drummy case actually already covers Win 2. Win 1 existed at the time that enforcement action was brought, and it went through the court system, and it took 4.5 years, and we learned that, yes, Win 1 should have received a special permit. When I filed a new enforcement action for Win 2, once I knew that was the law, I wasn't entirely sure it was needed. I wasn't sure if it didn't come under the umbrella of the Drummy case already. And when I received this binder from the town, I was very interested with tab 4. Now, if you look at the table of contents, you'll see that tab 4 is identified as Win 2 approval and permits. Not Win 1, but Win 2. So if I go to tab 4, the first thing I see is the special act of the Massachusetts legislature that gave the town permission to go into the utility business. And in the first sentence, it reads, the town of Falmouth may design and install wind energy facilities, plural, at its wastewater treatment facility at Blacksmith Shop Road. I'm not sure that that general license from the legislature controls local zoning, but it's interesting that the permission needed from the state covered more than one turbine. But if you turn 2 pages further, you come to what is undoubtedly the key document in this entire case. That is a memo that was prepared by Brian Curry and delivered to Eladio Gore on May 13th, 2008. That's 6 days after Mr. Weah had prepared the special permit application for Win 1. And what the town planner is saying in this memo is, if you agree that no special permit is needed, please sign this memo, which he did on May 13th, 2008. Now, keep in mind, we're in the section on permits for Win 2. But this memo, the Brian Curry memo, was for Win 1. And it's very interesting to note that the town did not go back to Eladio Gore, the building commissioner, and ask for a new interpretation of the zoning bylaws. So the first party in this room that treated Win 2 as being kind of co-joined with Win 1 under a single umbrella is the town of Falmouth. it could have gone back to Eladio and said, hey, by the way, for Win 2, we would like you to give us a determination letter, and it didn't do so. So if the town has treated Win 2 as being under the umbrella of Win 1, it is quite possible, and again, you may have to get guidance on this point from your council, that Win 2 is already under an obligation to have received a special permit. So now we get to these two boxes that we're confronted with. One is the 30-day appeal period. The key time frame is March 18th to April 18th, 2010. The building permit was issued, and I have pointed strongly to Linda Okagawa. It's important to remember that Linda lives closer to either turbine than any other resident in town. And Linda gave an affidavit. The original was delivered when we met last. And in her affidavit, she says, I didn't know anything about Win 2 until Malcolm Donald knocked on my door in October of 2010. That's well past the 30 days. So I think in terms of that box, we really don't have a case where there was actual constructive knowledge of the building permit sufficient to trigger the requirement to take action. The town has mentioned it was in the general domain, but the courts have ruled pretty clearly that it can't just be general information about a project. It has to be knowledge that there was a building permit issued, and you need to investigate that within that first 30 days. So really, as Attorney Watts said, we come to laches. Laches says that even if you're within the 6 years, and as you know, our zoning statute, in my opinion, is a little bit broken. We've got 8 plus 14 plus 15 that gives you 30 days, and you got Section 7 that gives you 6 years. And I think our courts have struggled with this. If you knew about the building permit, you got only 30 days to appeal. If you didn't, you've got 6 years. And this confuses the judges, and they don't know how to deal with it. And they've taken this equitable remedy that has existed in our legal system since before we were a country, the doctrine of laches, and brought it in to try to help fix what's probably a broken zoning system. And there are 4 elements. First of all, you should know it's an affirmative defense. So even though we're within the 6 years, the town is grabbing onto laches and saying, we can defend ourselves against this claim that we're untimely, but it's their burden of proof. So if there are factual questions that you don't know the answer to, and you're not sure whether the doctrine of laches should bar this enforcement action, it has to be determined in our favor if you're balancing things because the burden is on the town. It's a question of fact, and it gets resolved on a case-by-case basis. And this is a very unusual set of facts. So I think you have to decide, should Linda Okagawa and Barry and Diane Funfar have brought an appeal as soon as they did know about Win 2, or did they have the luxury of waiting and bringing that enforcement action after they knew it was a good cause of action? I mean, they were looking at the appeals court. First the trial court, and they lost the case. They went to the appeals court, and it was successful, and then it went up to the SJC. So there was a reason to wait. We thought we were under the umbrella of Win 1 anyway, but in addition to that, we thought we were keeping our eye on the 6-year statutory time frame, and we brought this enforcement action within that period, 5 days after the SJC ruled. But then you get down to the 2 issues that are the nuts and bolts. One is the reasonableness of the delay. Was it reasonable or not to delay in bringing the Win 2 enforcement action? And the detriment to the town. By the time Linda Okagawa learned about Win 2, October of 2010, the construction contract for its erection was already signed. That was done back in January 15th of 2010. The August 3rd letter from the town to Vestas saying, yes, we take full responsibility for the siting of Win 2 was already sent. And the town was well aware of the distress and the request that was being processed with regard to Win 1, the lawsuits about whether or not a special permit was needed. So I'll end by going all the way to 1910. Sometimes in the cases we look at, you find verbiage that goes very far back, and it sometimes provides the best words that we can chew on and reflect on as you try to decide this very difficult question, keeping in mind those 4 points. So this is a case that is in the binder provided by the town. It's the case of DeWolf versus Apovian, but I'm not going to close by reading that case. Within it, there's a quote from the case of Stewart versus Finkelstein, the Supreme Court of Massachusetts. If there has been unreasonable delay in asserting claims, or if, knowing his rights, a party does not seasonably avail himself of means at hand for their enforcement, but suffers his adversary to incur expense or enter into obligations or otherwise change his position, or in any way by inaction lulls suspicion of his demands to the harm of the other, or if there has been actual or passive acquiescence in the performance of the act complained of, then equity will ordinarily refuse her aid for the establishment of an admitted right, especially if an injunction is asked. It would be contrary to equity and good conscience to enforce such rights when a defendant has been led to suppose by the word or actions of the plaintiff that there was no objection to his operations. So there was objection. There was objection to Wind 1, identically situated with Wind 2. There wasn't acquiescence. We weren't within the 30 days, and I don't think we lulled the town into anything. I don't think they changed any of their decision-making. I don't think they entered into a contract that they wouldn't have had they known that we felt that Wind 2 should be included with Wind 1. So I think this antique language helps us, and it's in the binder before you. You have these 4 things to consider, and I wouldn't call this a close call, but I would call this a very interesting legal question. And please don't shy away from being the court. This is a quasi-judicial exercise here. You are the court of first instance, and it's case by case, and you need to make a decision about whether or not you feel we put the town in a bad position by waiting until the court system had let us know this was a good cause of action. Thank you.
Attorney Sane, do you want your, well, I guess Attorney Tillotson, are you going to go first? Is that
I think-
or was it the, I
It was the
apologize.
clients, I
The
think,
clients
were gonna go
next.
first.
Okay,
And
thank
board
you.
questions.
And board questions.
Well, finish up that
Right.
side and then turn to the other.
Okay. So, Attorney Sunny, if there's a couple out of public comment, like I said, we'll restrict it to 2 minutes per person.
I'm Linda Okagawa, 821 West Falmouth Highway. I'm 1,225 feet from Win 2, my home is. Since February 16, 2012, when Win 2 began operation, I've experienced the following daytime symptoms in the presence of the operating turbines. Headaches, ear pain, pressure and popping, balance problems, debilitating fatigue, mental confusion, lack of focus and productivity, body tension, stress, dizziness, queasiness, and heightened sensitivity to flashing light. I'm affected both outside of my property and inside. My distress is greatest while inside with the windows closed. When I'm away from home or the turbines are off, my symptoms generally lessen over a period of time. I'm often compelled to leave my home for relief. I'm a turbine refugee. Perhaps you remember Veterans Day last week. In short, here's how my day went. November 11th, 2015, 7:40 a.m., rain, loud roaring outside. 8 o'clock and on, dizzy and shaky, off balance, walking, queasy. At that point, it was a north wind, 22 miles an hour with gusts at 35. 10 o'clock, still roaring outside, very audible inside. 1 o'clock, been hiding out in the basement all day. Bad headache and dizzy when go upstairs. Packing to go out. 1:10 or so, Wind 2 went off. Don't know why, but I'm so thankful as I haven't been able to accomplish a thing today. 1:15, back on again and roaring like a plane. Darn it. Have to go out to stabilize myself. At that point, it was 24 miles north, 24, and gusts of 37. At 4:30 outside, I felt better and returned home. I was floating around Falmouth trying to find a place to rest. Then it was northeast at 18 gust 31. I had to stay in the basement, and it was still loud. So I'm determined to protect my good health. Thus, I have to go away from home. As Attorney Seni has documented, there has not been a comprehensive investigation with respect to the operation of Wing 2. The special permit process promotes due diligence in the detailed evidence, and prudent, informed, and independent judgment are applied to ensure there are no adverse effects. An adverse effect that is particularly disturbing to my husband and me is intense and prolonged shadow flicker, causing headache, dizziness, confusion, and visual discomfort. These are the effects on us and visitors when the strobing encircles our yard and enters our house. This year it has just begun in mid-October. Like other years, it will likely continue until the end of February, so it will be all the way to 2016. The Falmouth Planning Board spent months and months educating themselves about wind turbines before creating the town's wind energy bylaw. Unless you are fully informed about the daytime effects of Wind 2 and understand the impacts of what is likely to occur in the coming months, high winds, 4.5 months of strobing flicker, the need to stay indoors with the doors and windows shut. These are all factors that aggravate the distress of those living too close to industrial-sized turbines. If you don't understand this, you can't fairly judge the impact of the building commissioner's denial of enforcement. Before proper studies and
Mrs.
analysis...
Okugawa, I hate to interrupt you because I
This
know...
much.
I just want to be consistent with everybody, and I've already indulged you a little bit. If a short paragraph.
Okay.
And I do apologize, but...
No, it is a short paragraph.
Okay, thank you.
Before proper studies and analysis are done and discussed in a public process, what evidence do you have that it is prudent to run Wind 2, that you can judge if there are adverse effects on the neighborhood? Since you don't have enough relevant information until the special permit process is completed, then, you should not run the turbines until the special permit process is finally done. Please turn off Wind 2 now. Thank you.
Thank you.
Okay.
Clerk, great, thank you.
Christy Funfar, 50 Old Dock Road. I'm reading this for my father, Barry Funfar, of 27 Ridgeview Drive. Quote, "This neighbor of the Falmouth wastewater treatment plant has been involved since March of 2004 in the town's move into wind power. In hindsight, it is to me a case of the town's lack of due diligence, failure to investigate the risks involved, not following and even breaking the town's own bylaws, deceit of a bait and switch nature, that is, building two 1.6 megawatt turbines rather than the proposed 660 kilowatt machine, and worst of all, allowing the fracture of this community to continue. This amounts to a huge case of fraud and deceit. Even town meeting was not told the potential negatives nor the size of the wind turbines at any of the 3 town meetings they were asked to support the project at. After all of the above mistakes, the only problem now is that the selectmen will not admit that any mistakes were made. They continue to push a second class of citizenship in Falmouth by denying full rights and freedom to neighbors of their failed project. These wind turbines were wrongly cited. For their size, they are simply too close to a population of Falmouth citizens. No wrangling over finances can correct this problem. Please cease the operations of Falmouth's Wind 2 turbine, just as you have that of Wind 1. These 2 wind turbines are equally intrusive and detrimental to my family, my home, and myself. Thank you for listening, Barry Funfar," end quote. I was wondering if it was okay to say a few words of my own words. My dad was treated for PTSD resulting from 19 months as a Marine in Vietnam. He survived 127 missions as a Huey helicopter door gunner. My parents' residence at 27 Ridgeview Drive has been my dad's safe zone since 1979 when we moved into that house that my dad not only designed but built every part of himself. He then created a massive woodland garden, which truly became part of his therapy for the PTSD, combined with working with the VA, where he received and still receives individual and group therapy. For anyone who knows my dad or had the pleasure years back of walking through the paths he had throughout his gardens, knows that this was a therapeutic passion of his. 27 Ridgeview Drive actually used to be one of the stops of the West Falmouth Garden Tour. Today, though, one would barely be able to locate these paths. Since the startup of the turbines, my dad's success at managing his PTSD has slipped backwards. He not only hears them, he feels them. He has been unable to work outside in his yard at his own home. The effects on his mental and physical health are so extreme that he has to frequently leave his home of 36 years, and this is why they're not here tonight. Because yet again, my parents, because yet again they have needed to temporarily escape the turbines. Traveling is great, but usually one nice thing about traveling is the home sweet home feeling you get when you return. My parents no longer have that, with the turbines severely invading their health, their lives, and their well-being. They certainly never expected to spend their retirement time or retirement savings on fighting to be able to remain in their home and to regain that safe zone that they worked so hard to build. My dad very recently shared with me that after his returning home from Vietnam, feeling unwelcome by society, that a large contingent of Falmouth citizens has brought back these same feelings for him. Please shut down Win 2. Thank you.
Thank you. Is there anyone else? Okay. Is it just?
Is Anderson, is Mr. Anderson?
May I reserve the right to possibly comment a little bit later?
Well, we're going to be, so this is what's happening. There will be public comment for the special permit application later. But right now, since we did have public comment on the appeals last time, we are trying to limit it so we can move this, kind of keep moving. So if you want to speak to the appeals, I believe you spoke last time, but you're welcome to again.
Do I have to go now?
Yeah, well, yes, I think that's
It's
the,
only 2 minutes, whether it's now or later?
yes, because we're going to ask questions, then Attorney Tillotson's going to have an opportunity, just to keep it orderly. Thank you. Matt, are we, is it everybody?
I'm
Yes.
sorry,
Yes.
and again, I apologize, but are you asking for comment from all members of the public at this point?
Just those who want to speak on the appeals, correct?
I guess I would defer, I know council spoke, and I know you work out your own thing, and then, so I want to make sure I'm,
I thought it was going to be just clients first, litigants first,
and then you would,
and then me,
Okay.
and then members of the public in
Okay,
general. It's
understood.
subject to the board
Okay.
asking questions.
thank you.
apologize.
No,
No, that's right.
I wrote down notes earlier, that's helpful, thank you. So, but we will be asking questions. I think it makes sense to ask questions of attorneys Watt and Senni now, unless anybody else disagrees. That way it's sequential, unless you
Well,
want to.
I was thinking that
You want to hear from
Attorney
the town
Tillotson
first?
might
Okay.
clarify some of the,
Okay.
at least I'll have her perspective if I
Okay.
do have a question.
Perfect, so we'll do it that way.
Thank you.
Thank you.
Thank you very much, members of the board, Madam Chairman, and members of the public. Diane Tillotson, representing the town of Falmouth. With everything going on in the world and everything going on in all of your lives, I'm sure, I would be remiss if I didn't start this presentation the way I meant to end my presentation the last time I was before you, which is to say thank you to each of you on behalf of the town of Falmouth. I know that you've spent an incredible number of hours poring over the voluminous materials that we have submitted to you, sometimes at the last minute and untimely. And I think all council apologize for doing that. But this is a very difficult case. It involves the interaction of law, science, medicine, and a whole lot of emotion. And I know it is not your typical zoning setback case, and I just want to say again on behalf of the town that We really appreciate the time and effort that you're putting into this. I have just a few comments on the enforcement. I'd like to ask, first of all, that you continue to examine very critically the evidence and the testimony before you. Ask what the sources of the testimony are, what the qualifications are those who are speaking, whether there's any possible bias from anyone that you're hearing from. Another point I'd like to make is that this is a public project. The town of Falmouth is the applicant in the special permit case and is the respondent here. And the town of Falmouth is somewhat different from your usual cases because in addition to being the applicant before you, they are also representing the people of the town of Falmouth. And unlike the typical case where you have a developer or a landowner who might be coming to you for zoning relief or being challenged with respect to a pending enforcement order, in this case, there are a whole lot of members of the public who do not want to see Wind 2 shut down, some of whom are neighbors to the Wind 2 project, and some of whom live as close as the applicants for zoning relief in this case. And I think you have letters from a lot of people in your file, and I would encourage you to read those letters and emails. I know Sari has been providing us with copies of all the letters that come in, and again, I would just encourage you to read those and to consider the fact that this is a project that was put up for the public good. I'd also like to focus now a little bit on the presentations that you heard from Attorney Watt and Attorney Senni. Wind 2 is different from Wind 1 in several critical respects. And I'm not going to repeat the presentation I made last time. I'm not going to go through the case law. I trust that you have it in front of you. But I would like to make a few comments. First off is that Wind 2 was part of a public process. There were votes taken townwide that resulted in leaving Wind 2 running even after all the issues with Wind 1 were well known. With respect to Wind 2, the only turbine that was ordered shut down by a court was Wind 1, or I'm sorry, the only turbine for which the court determined that a special permit was required was Wind 1. And there's a reason for that. But Wind 1, again, was at the time the applicants for zoning relief here sought zoning relief for the very first time from the building commissioner. Wind 1 was already up, it was operating, it had been operating for several months, and the town had accepted the turbine. So at that point, it shouldn't seem at all surprising that the town, being confronted with a zoning enforcement request asking them to seek a special permit that their town council, building commissioner, and planning director had already told them that they didn't need, would just continue to allow Wind 1 to operate and allow the court to make that decision, which is exactly what happened. The town respects the decision of the appeals court, and as a result of that decision is before you here tonight and last time with respect to Wind 1. But there is no judicial determination with respect to Wind 2. Part of the reason for that is soundly in the lap of the applicants for zoning relief, because they didn't come to you and seek zoning relief with respect to Wind 2. You heard from Chris Senni and Linda Okagawa. Linda Okagawa says in the very same affidavit that she filed with this board that she didn't have a particular problem with Wind 1, excuse me. Wind 1 and Wind 2 affect different people differently. And Linda Okagawa said she didn't have a particular problem with Wind 1. But she also says in that same affidavit that she learned about Win 2 in the summer of 2010 when Malcolm Donald knocked on her door. The fact that these folks sat on their rights for 5 years is a classic example of latches. And the convoluted analysis that my fellow counsel have attempted to present, shifting the burden to the town and saying, well, the town had constructive notice that they needed a special permit because we appealed on one they should have known, has no basis in the law. And I cited an example. If you are going to complain about a particular building, a particular structure, a particular project, you cannot sit on your rights and wait for 5 years and wait and see essentially whether your litigation on a similar project or even an identical project is determined to have merit by a court of competent jurisdiction. It would have been very easy for these folks to join their appeal at both before this board, you would have done this 5 years ago, before the Superior Court and before the Appeals Court. Again, latches, it's a classic case of latches. The other critical distinction between Win 1 and Win 2, in addition to the fact that there was no adjudication, a very public process, there was no question that these abutters knew about Win 2 well before the case at hand. I'd like you to also look at the alleged harm suffered by the Funfars, the Linda Okagawa, and Anderson. With respect to Mr. Anderson, I frankly do not understand why he also is appealing Win 2. Most of the impacts to him are on Win 1. Win 1 has been shut down, and for the record, the town does not disagree that this board's decision with respect to the cease and desist for Win 1 should control that piece of that Anderson case. We're not coming to you and saying, we want you to change your mind on Win 1 at this point. We are committed to going through the special permit process and to attempting to convince you that a special permit is warranted, a properly conditioned special permit is warranted for Win 1. I'd like to look at the Funfars and Ms. Okagawa for a moment. Again, I don't believe that Mr. Anderson is particularly affected or aggrieved by Win 2. With respect to Ms. Okagawa, she brought a nuisance complaint before this board with respect to Win 2, which this board determined did not make a finding of nuisance in her case. She appealed that finding to the Superior Court. As a result of that, the court entered the preliminary injunction that the town is currently abiding by and will continue to abide by with respect to Win 2. There was no timely zoning appeal taken with respect to the building permit on Win 2. I would therefore respectfully urge you to leave that nuisance case in the court. This board did find nuisance in the Funfar matter, and of course the town appealed that, and that is also pending in the Superior Court, and that is also the subject of the preliminary injunctive relief that has been granted. I listened to Ms. Okagawa testify this evening, and I listened to her one other time. I've seen her answers to interrogatories in the nuisance case. And I want to be respectful when these people come before you to testify. But as a lawyer, I have to tell you that we're somewhat hamstrung in presenting before a Zoning Board of Appeals because we don't have a very powerful tool of cross-examination. I can't stand before you and subject Linda Okagawa to that. What I can do, and I have copies of a report by a noted medical professional that I'm going to provide to you. He will be speaking to you. It's Dr. Robert McCunney. on the special permit case. But I'm going to provide you with copies of his report this evening. And it's pretty dense stuff, frankly, but I do want to call your attention to just 3 or 4 pages of that. The first page is 3 pages in, it's E110, and it's the table at the top. Medical, and this is consistent, it's not just Dr. McCunny, medical studies that have been done on sound and noise in general clearly state, and this is not anything that's close or fuzzy, the threshold for pain, ear pain, hearing pain, is above 120 decibels for sound pressure. There is no question that these turbines are not and I have not given you that yet, so I'm going to just hand it out. I didn't want to distract you by giving you yet one other report, and there's only 3 pages in this. Actually, I'll hand it out now. I'll need 1 second for that, but I'll hand that out in a minute. So it's the 3rd page in, and then it's just pages 125 and 126. And again, we're going to present a lot of this during the special permit, and I present it now only by way of refutation of, or something to think about with respect to Ms. Okagawa's testimony. There is no medical evidence to support that the symptoms which she reports, which I believe are real symptoms, are connected to the wind turbine. There is also a very real psychological phenomenon, which is known as the nocebo effect, which Dr. McCunny will discuss in detail when he comes. But again, I just wanted to call your attention to just a couple of pages in this report, which I will also submit and have discussed in greater detail during the special permit application. The last, and very briefly, I just want to say with respect to the flicker, flicker is something that is very individualized. What the science has told us is that in order to experience shadow flicker from a wind turbine, the turbine has to be between you, and in this case, because all of these turbines would be east of these properties, have to be between you and where the sun rises. And it's only possible to get shadow flicker, which is the same thing that you see as you're riding down a shady street in a car or on a bicycle sometimes, and you see the sun kind of flickering in and out of that. Same phenomenon, but it's only possible at certain times of the morning, in this case, and for very limited time periods, and obviously on sunny days, because the sun has to be behind the turbine. The effect can be easily mitigated, and again, it also has to do with the way a particular home is sited. If your home is sited so that your windows are facing east, and you happen to be looking out those windows, you're going to see shadow flicker. But through a mechanism of even as simple as providing shades, it's for a very limited time period. It doesn't exist for hours and hours. It's a matter of minutes in the morning, if it's a sunny morning. And the town is committed to addressing the shadow flicker issues on an individual basis where they occur. And we have offered to meet with people experiencing shadow flicker and to provide that mitigation and relief, and we will continue to do so. And I just want to make that point very clear. That is all I have. I would respectfully ask the board to deny, based on the very strong, I believe, legal position that we have on latches with respect to Wind 2. I would earnestly ask the board to deny the request on Wind 2 for a cease and desist. And I'm happy to answer any questions or sit down and let you ask questions of anybody else.
Okay, thank you. Let's see. How does everybody feel about questions? Would you like to? I certainly have a lot. Maybe we ask questions of Attorneys Sunny and Watt first, and then we go to the town, if that works. for everybody.
I'm sorry.
Oh, I was looking at you, but I guess the whole board. Questions? Do you have any preference what order we take them in? Okay, so we'll say Attorney Watt, you spoke first, so we'll give you an opportunity if anybody has questions for you. Paul?
Yeah,
I don't know.
just a quick question, because I'm not a lawyer. Is latches when you knowingly sit on your rights? Latches, am I phrasing that correctly? Latches, when you knowingly, when you know that there's some sort of an issue there and you watch your neighbor continue, it must be, right?
Well, I'm not sure knowingly is an element of it. The courts have described it as an unjustified, unreasonable delay in bringing your rights. There certainly would be some knowledge requirement to be shown that at some point you knew of the project. So that's not disputed, that at some point the Andersons knew of it. Certainly it was up at some point, certainly by 2012.
Right. Okay. Thank you.
Ed?
No, I don't have any questions right now.
TJ?
Can you come back to me?
Sure. Ken?
I guess my big question revolves around the relevance of the SJC decision to the Wind 2 case. The requirement for an appeal, the requirement for a special permit pertain to Wind 1. Does it have any relevance in your view to this Wind 2?
Well, it certainly does. I mean, these are identically sized turbines. They are identically situated in the same zoning district. The town's argument all along was that the wind turbines constituted a municipal use as of right. That argument was rejected by the appeals court. And the appeals court held that all wind turbines are controlled by section 166, which requires a special permit. So just as a factual matter, they are the same, and Wind 2 did not receive a special permit. So that's why I say they are identically situated.
So you believe from a legal perspective, it has some, it binds on Wind 2?
Well, I think the town would concede that absent the question about whether this is a timely appeal or not, that in fact, the facts of both turbines are the same and would have the same requirements under the zoning bylaw as Wind 1 and Wind 2.
That's it.
Okay. In the Andersons affidavit that you submitted, you said that they knew of Wind 1 as of March 23rd, 2010.
Correct.
When did they know of Wind 2?
I don't know. Possibly the following fall. I'd have to ask Neil, but
That's okay. So you're saying following fall, they knew about Wind 2.
I really don't want to speak for my clients, but it may have been the following fall after the enforcement action had already been begun on Wind 1.
Well, wasn't that the point, I guess, of all of this when they had knowledge, right? Whether when they had actual knowledge or constructive knowledge as to Wind 2. This concerns Wind 2. And so that's omitted from the affidavit, right? It's not provided in there.
Correct.
Okay. So, but we'll say the following fall, even though you don't want to speak, but around that time. I also believe it's in the affidavits and that they were meeting with the town from between March and August regarding operation of Wind 1.
Correct.
Do you know if they had any communications with the town about Wind 2 at that time?
Not to my knowledge, they didn't. Everything was geared towards Wind 1.
Were you involved at that time?
I was not. I was not involved until, I think probably the beginning of August.
So, okay, but were you meeting with the town then
No,
once you
I
were
didn't.
retained?
No, I did not.
Okay. So I'll write this down so I have it. Okay. Okay. And the building permit was received in, I'm sure I have this somewhere, March 2010, is that accurate? Or was it April
March
2010?
18th or March 18th.
And then it was constructed the next year, is that correct?
I don't know. It began operation in 2012. I don't know when it physically
Was
went
constructed.
up in the air, when the boom.
Okay. I think during the last hearing, you had said that and correct me if I'm wrong, I might have misheard you, that the burden at this stage was that on the town to show that you had received notice. Does that sound accurate, or am I mischaracterizing it?
Well, to show, the town has conceded that there is no shown actual knowledge. The courts then step in and show whether you have a duty of inquiry during that 30-day period to inquire. Now, all the Andersons knew was that when one was up, that was within that 30-day period. How that imputes a duty of inquiry with respect to Win 2, I think is slim, if not none. Unless the town says that you have a duty to go down and look at the building permit when you know that the structure is already up. There's nothing additional to be necessarily learned in that case. When you see a structure up, why do you need to go down to the town to look at that permit?
Well, I guess my question with respect to this is say we believe the town, okay? They show that you didn't have actual, or they didn't show, there was no actual or constructive knowledge.
Correct.
But you could still have standing, right, at this stage? If you make a showing that the Section 7, despite the fact you didn't have knowledge within the 30 days, that once you gain knowledge, and I'm reading out of the Connors v. Nino case, an enforcement request may still be pursued under Section 7 if the aggrieved party, so that would be you, can establish that you did not have adequate notice.
Correct.
Okay, so you think that you've met that burden at this stage to sustain your standing?
Well, I'm not sure there's two different things here.
Okay.
There's a standing issue, which incidentally, I don't know if the town is now raising aggrieved party status. Whether one is aggrieved is a different issue entirely as to versus whether you are in correct statute of limitations.
Okay.
The statute of limitations goes to your jurisdiction to hear an appeal. 30 days is the appeal period. If you have actual knowledge or knowledge sufficient to put you on a duty of inquiry. If you're past that period, if the town doesn't show that there was actual knowledge or there was notice sufficient to put you on a duty of inquiry, you then enter into the 6-year period. And the only argument there is whether you've rested on your rights once you have knowledge. But
Okay, so that's leads me into a next question.
That's the latches argument.
Right, so your clients knew, you said it fall 2010, so it's 5 years ago. So they brought this appeal a little less than 5 years later, that's correct?
Correct.
So I think that there's some recent case law, and I guess this would speak to the latches argument. I'm reading from Allison, it's the Falmouth Zoning Board of Appeals. It was a 2014 Justice Long decision, and he says, persons who lack adequate notice of a zoning violation and sufficient time to challenge it within 30 days, which is what we're saying here, of issuance of the building permit may not sit back for the remainder of Chapter 48, Section 7, 6-year period. Once they have such adequate notice, either actual or constructive, they must act promptly. So I guess my question to you is, how have the Andersons acted promptly with respect to Win 2?
I presume in that case that Judge Long cited latches as the operating
Finality,
rule decision.
long settled expectations about, I believe he does go on to speak about latches, but I could be wrong. I reviewed it.
And I would understand that to be a land court case.
It is.
Which is not a case of precedential value on this
Right.
court. That would be the appeals court and the Supreme Judicial Court. And the Supreme Judicial Court have solely spoken in terms of latches, whether something is unjustified, unreasonable, and it works to
Okay,
the detriment.
and just because I have a lot of questions to ask you, how has your client acted promptly with respect to Win 2?
Well, the issue, again, because of the identical nature of Win 1 and Win 2, Win 1 was already in litigation. Now, if my clients, if you say that my clients have to bring another case on an identical basis, I'm not sure that's reasonable when the identical issue is raised in a pending court case. They don't have the funds necessary to run all the litigation. The town has virtually unlimited funds to fight this litigation. So
Okay.
that's really the nub of it.
Okay, and I will, I guess, just close up my questions as to this. How is your client harmed by Win 2 versus Win 1? So Win 1 shut down, is it the same harms? Is it the same degree of harm by Win 2? Is it the exact same symptoms? What is the harm, and why do they have standing as to Win 2?
Well, this goes to a point of order that I was going to raise too. Mr. Anderson did not speak specifically with respect to Win 2, but I believe he spoke with respect to Win 1 and Win 2 originally. It seems like the town had now raised, I don't see it anywhere in the papers here before, that possibly the Andersons are not aggrieved parties. Maybe they're not affected by it. So I think he should be given an opportunity to speak to the board as to how he is affected by Win 2.
Okay, and we'll open it up for the public, but I'm asking you, why does your client have standing?
Because he is still affected by Win 2. In the absence of Win 1, which the Win 1 has been shut down, they are still affected by the noise. It's still in a direct line, Win 2 to Win 1 to the Andersons' home. There's still peculiarities about how the sound travels there. There's a swale in the topography there, which seems to direct everything down towards the Andersons' home.
Did your clients make any complaints to the building department about Win 2, or were they all directed at Win 1?
Certainly they did. Win 1 and Win 2. They made several nuisance complaints, one of which is now pending in Superior Court, and in which Judge Muse found the Andersons aggrieved, affected by...
As to Win 2?
As to both Win 2.
As to both?
As to both.
So he didn't
Issued the
distinguish? He didn't distinguish?
No, he didn't distinguish.
Okay.
No, he didn't distinguish.
Okay. Okay. All right, that's all I have. Let me see. TJ, do you have any questions?
I think some of that got clarified for me.
Okay. Everybody else is all set, Attorney
Yeah.
Bob?
If I can just add one more thing in response to one of your questions about latches. Latches is, as Attorney Senni said, it's an affirmative defense. It's not something that we have the burden of proof on. The burden of proof is on the town to show that we acted unreasonably. And I would suggest that the Andersons did not act reasonably under all the circumstances, nor has the town shown any detriment.
Okay. Thank you. Attorney Senni, see if anybody has questions. Ken?
Hold on.
Oh, okay. Paul?
No questions, thanks.
Okay. Ed?
No. Not at this time.
TJ?
Oh, I need another minute.
And Ken, you need a second?
Well, I guess I'd ask the same question regarding the relevance of
Okay.
the SJC case, in your view, to Win 2.
If we set aside the question of timeliness or latches, I can tell you through the two doctrines, the doctrine of collateral estoppel and the doctrine of res judicata, our court system would not make these parties relitigate whether Win 1 or Win 2 need a special permit. That issue has been decided by our court system, and there is no practical difference between the two. So we're here tonight because we have questions about timeliness and latches, but if the unhappy party after this board takes a vote gets to court and makes a claim that Win 2 doesn't need a special permit, the other party is going to move for summary judgment, and the court's going to look at the SJC and the appeals court case and say, that's already been decided. And we tend in the law not to make parties relitigate issues that have been fully litigated.
Okay.
You're on second?
Mm-hmm.
TJ?
All right. And I'm looking through your October 28th letter to the board. In terms of Win 2 with Ms. Okangawa, what was the town's legal requirement for notice concerning the building permit of Win 2?
What was the town's requirement?
The legal requirement for notification.
There is none.
There is none.
Actually, one of the cases cited frequently in this discussion, I'm not sure if it's Connors or Gallivan, but in a footnote, the court said, you know, towns could avoid this problem if any time people applied for a building permit, you were required to publish notice in the newspaper, and that would solve the problem. But the town was under no obligation to give notice that a building permit had been applied for or issued. They could have. There's nothing to keep a landowner from doing that. In fact, I have advised clients at times to do so to avoid the 30-day versus 6 years. But there's no obligation to give notice.
You're all set? Some of my questions for you, Attorney Sane, might be duplicative of what I was asking Attorney Watt. But you said, and I think this is what Ken was speaking to, you said that Win 2 is under the same umbrella as Win 1. But Win 2 affects different people than Win 1. Isn't that true? Including Linda Okagawa, is that correct?
That's correct.
So in 2010, that's when Ms. Okagawa became aware, is that?
That's correct.
Okay, so October 2010?
Yes.
Okay, that was the first time she knew about this. Why wasn't an enforcement request sought once Mrs. Okagawa knew about Win 2?
It's a good question. It's a fair question. So in October of 2010, she learned about Win 2 and saw a map that showed that it would be pretty close to her home. She put her name on a list that the town had of people interested in the turbine project, and so then she did begin to receive notice, and she began to attend meetings. Now, she still didn't know in 2010 and 2011 that Win 2 would cause her adverse impacts. But the question could be extended. In February of 2012, which is several years ago, she knew about the illegality claim as to Win 1, and she knew that Win 2 was adversely affecting her. So why didn't she initiate an enforcement request and bring the case here and then on to court, perhaps to be joined with the one that was already in progress? I began to represent Linda Okagawa in late 2013. I think a statement was made several weeks ago that I've represented her all along, like I have some of the other clients more impacted by Win 1. But I began to represent her in late 2013 in connection with her nuisance appeal from this board. And I could have at that time, when I became her lawyer, said to her, hey, you know, you're impacted by Win 2, and it's possible that the Drummy case only affects Win 1, and maybe we should file an enforcement request and take it up through the system. That might be my fault. It is certainly the case that when I got involved, or even at some point after the Win 2 began to operate, an enforcement request could have been brought. And that could be my fault, and it certainly could have been done. However, you were talking about the decision from Judge Long and where we are on what may become a new rule, but it's not the rule. And that is that if you don't fit within the 30 days, you don't just get 6 years. You should get 30 days from when you learn of it. And legal scholars like Mark Bobrovsky and other leading attorneys in land use, and even Judge Long as he worked his way through that case, are edging their way toward a new rule, which is that it's 30 days from the issuance of the building permit when you know about it in time, and it's 30 days from when you know about the problem if you learn about it later, but you don't necessarily get 6 years. That is not the rule today. It hasn't been recodified. Our statutes read the way we've described them. The judges aren't changing the way those statutes read. They're beginning the process. This is what the common law does. They're beginning the process of thinking that our system doesn't work. It's not fair to people if you can wait. Now, this is a very unusual case. So the rule is 30 days or 6 years, and what the lawyers and judges have done is leaned on the doctrine of latches to try to make it more fair. And that's all we have. We do not have a new rule. We have the doctrine of latches, and that's the one that says that you're only going to be prevented if you fall between 30 days and 6 years if it was to the detriment of the other party. And I don't think it was. I think the town of Falmouth was full speed ahead on Win 2. I don't think they were going to adjust any contracts they entered into or do anything differently. And so I don't think they meet the doctrine of latches test. I do recognize that my client who did not know, she certainly is not within the 30 days, and the Funfars also did not know about Win 2 within the 30 days, could have done this sooner. But we don't have the rule that Judge Long is sort of writing about in our statutes yet. We may get there, but at this point, it is the doctrine of latches that we deal with, and I don't think the town was in a worse position. Also, as I already articulated, I'm not sure Drummy doesn't already bring about this result. Keep in mind that, let's say we're at year 11 tonight, so we're out because we're not within the 6 years. The fact that we're at year 11 doesn't make Win 2 legal. What happens when you don't meet that Section 7 time frame is that the illegal structure or use is unassailable, but it's not made legal. So today, Win 2 is not legal because of the doctrine of res judicata and collateral estoppel. We know that our court system feels that this kind of turbine in this location needed a special permit. The town could apply for a special permit for Win 2. And when we got the final word from the SGC, I expected that the town would do that because the principles apply equally as well to Win 2. But the town isn't doing that. What they're doing in this proceeding is telling the town and the public, we are not planning to apply for a special permit for Win 2, even though the law requires it. And they could do it. They could just simply file an application, and they should. You shouldn't decide for us because of what they should do. You should decide for us if you feel that the doctrine of latches does not prevent this enforcement.
Thank you, Attorney Sunny. Anybody else have any follow-up? Attorney Bobrowski, I forgot to ask you last time. I didn't know if you...
If I need to butt in, I will.
Okay, thank you. And I think we'll go to Attorney Tillotson and see if anybody has any questions.
I first of all want to hand the board the article that I referenced the 3 pages from. Again, you're going to hear a lot more about this in the special permit process, but since I alluded to it, I want to include it in the record. I think I provided it by email earlier this evening, but
Oh, no, I haven't seen it.
Thanks, Diane.
Thank you.
Thank you. Thank you. And let's see if anybody has questions for you. Paul?
I don't, thank you.
Okay. Ed?
No.
TJ?
Kind of what I was going off of before. So the town's notification to the abutters was completely voluntary?
the town notified the abutters not, and I will be very clear about this in fairness to Mr. Sen and Mr. Watt. The town sent out no notice that said, we just granted a building permit. There was not any such notice. There was repeated communication relative to the plans for Win 2. The vote for Win 2 was taken at a town meeting held townwide and then communicated to abutters in the immediate area, people within 900 feet. And that list may have changed over the years because, of course, people sell their properties and move. But the general information about Win 2 was communicated fairly consistently through the process. In addition to that, certainly at the time that Malcolm Donald first spoke to Linda Okagawa, and I think this is even in her affidavit, he mentioned in the early summer of 2010 that Win 2 was on the horizon, was coming. And again, so she did have notice. And again, I think this is a fairly, I will agree that the question of whether there was constructive notice within the 30 days is a very close question. I think the question of latches is not close, because the one point I would disagree on with Mr. Senni is that it's not 30 days or 6 years. It's 30 days or within a reasonable time after you find out about the issuance of the permit, or could have found out. And again, it was a fairly simple matter. They knew that the project was going up, and again, the turbine didn't start operating until 2012, winter of 2012, but throughout that fall, they were closing the roads, delivering, and I indicated this in my most recent submission, delivering the blades. All of this involved a lot of public notice, required public notice by the public works folks in order to get the turbine materials to the site. And I'd just like to take issue also with the one point that it's all well and good for Mr. Senni to say that he doesn't believe that the town would have done anything differently. But recall that there were people that, and certainly Linda Okagawa had notice about Wind 2, as did the Funfars, as did Anderson, before Wind 2 was erected and operating. And if DEP, and we would have had to advise all our funding sources of the permit, that the permit was being challenged, the building permit was being challenged, had DEP and the funding sources known about an appeal, they very well might have said, we're not funding this, we're not going to grant you the funds to erect Wind 2 until you straighten out this appeal. So I think there is an impact, and I think to suggest otherwise is simply disingenuous. And I'd just like to answer at least my perspective on Mr. Foreman's question. I think that had there been an appeal of Wind 2 pending at the same time as the Wind 1 appeal, Mr. Senni is absolutely correct. The outcome in Wind 1 would have controlled. The fact that there wasn't is really the critical issue. The fact that there was the delay for 5.5 years to bring that appeal. And I think the context of zoning enforcement is important to keep in mind. It's all about timing. It's all about making a timely appeal to the board. I mean, as you know, the statute of limitations for appealing a building permit is 30 days. An appeal from a decision of this board or the planning board is 20 days. And the reason for that is because there is a very very consistent statutory policy throughout Chapter 48 that timeliness is important, and people can't sit on their rights because it prejudices projects that are in construction being financed. And for that reason alone, we would respectfully ask that you decline the enforcement request on Wind 2. Thanks.
Oh, I think I'll have some questions,
Yeah.
and I know
I'm
Ken
sorry.
might. You're all set, teacher?
Just a quick follow-up question. to the notifications, the 900 feet, what is the significance of that?
It was, well, first of all, given the location of this particular project, the wastewater treatment plant, it was, the determination was made, the ordinary notification to abutters that's required, for example, when this board holds a public hearing, is abutters and abutters to abutters within 300 feet under the statute. And there was a determination made to widen that circle of notice to 900 feet. It was made by the town's energy committee.
How's that? Ken?
A lot of dates and times to keep straight here, so if you could help me with a few of them. That, unfortunately, I can't keep in my head. When one started operation when?
March 18th, or in March 25th, I think, of 2010. Approximately a week after the building permit for Win 2 had been issued.
Started operation.
Right.
Win 2 started construction, or...
It depends on how you define
or let's say
construction.
finished.
Started operating
Yeah.
in February of 2012, was up by the end of 2011.
So if you were an abutter and you had no issue with Win 1, and you might have anticipated that Win 2 would be equally inoffensive, you might not act. Would that be reasonable?
That's conceivable until February of 2012.
Right.
Although there was a lot of discussion about Win 2, and there were people that objected to it. And
that may be, but I mean, at least Mrs. Okagawa is saying, I didn't have a problem with Win 1, so maybe she didn't expect to have a problem with Win 2. If at that time it started, then it would be reasonable that you might have sought some remedy.
That's correct. It would have been reasonable to seek a remedy, though, after February or March of 2012, because there were already complaints at that time. And I think I provided, last time, a log of when the complaints started coming in for Win 2, and it was pretty quickly after the turbine started operating in 2012.
And she first brought this in
2015.
2015. Now, if you weren't sure what, I mean, she knew there was pending litigation regarding Win 1, would it be reasonable to want to see what the outcome of that is before pursuing further action? Why or why not?
I would suggest that no, it would not be reasonable. And the reason is, again, at least as of the time that she was represented by counsel, which we now know was sometime in 2013, I believe is what Mr. Senni just said. At least as of that date, she had counsel. And as a land use lawyer, as a zoning lawyer, it is incumbent on you to, I think, explain to your client that if there is a project of concern to that person, you should bring an appeal of that particular decision. Whether, and frankly, I don't want to get into a lot of procedural stuff, but there are certainly ways the appeal could have been brought. It could have been brought first before this board, depending on what this board would have done in 2013. An appeal likely would have been taken by one party or another. At that point, either party, whoever's bringing it, could ask the court, there's a case that's pending, could say to the court, there's a case that's pending on this very same issue. The town won, was successful in the Superior Court. It's up on appeal, it's in front of the appeals court. We'd like you, Your Honor, to stay this until we get a decision. So you don't have to spend a lot of money litigating it. That's a very common procedural thing that lawyers do, and it would have been very possible to do, and it would have been likely that the court would have said, you're right, the legal issue, not the impact to the particular abutters, because I do have an issue with Mr. Anderson in that regard, but the legal issue is the same, the question of whether or not a special permit is required. So we're not going to require you to spend a lot of money litigating this. We will wait to see what the appeals court does with it. It could have been done. And certainly, Mr. Senni...
And what would be the motivation for not doing that?
I honestly don't know, because as a cautious lawyer who understands land use law, I would think that you would bring it, number one, to this board's attention. You would flag the issue for the town so that they know that Win 2 is also being appealed, because that's the other thing. They knew about the legal issue for sure, but by and large, the complaints around Win 2 were and continue to be much less than the complaints that began to come in fairly soon after Win 1. And the most vociferous of those complainers, Mr. Anderson, really didn't complain a lot about Win 2.
Okay, those are my questions.
Okay. I just have a few questions. The building permit was received in 2010. When did construction begin?
I believe that construction, and again, it depends on how you define construction. I don't think the turbine actually went up until, and I'm looking at Jerry, the fall of 2011. Is that correct, Jerry?
Yes, a little bit around October.
Was the building permit timely exercised? Or were there any extensions to that?
That's a good question. I believe it was timely exercised. I believe that there were a lot of things that needed to be done permit and funding wise. Again, the building permit was obtained. They needed the building permit in order to put the grants and the funding in place. And the lead time, although this turbine was already constructed, but the lead time on getting all of that in place is fairly extensive. I know that you're suggesting the 6-month building permit, and I don't know that it was extended, but certainly no one raised that in this case.
Okay.
Or frankly, with respect to Win 1, and with Win 1 it was a lot longer time period between when the building permit was issued and when Win 1 was actually constructed.
Okay. What is the harm to the town? I know Attorney Senni and Watt say, well, there's no harm to the town from us waiting this long. So how is the town harmed?
I'm sorry, how is the
town harmed by the fact that the appeal wasn't brought until this year?
Well, again, trying to look back 4.5 years to make a determination as to what the town might have done had they known of a pending appeal is difficult, because of course, Attorney Senni's speculating that they wouldn't have done anything differently, and I can't stand here and tell you, absolutely that they would have. But what I would suggest is that because Wind 2 was in a very different place at that time. First of all, remember again, at the time the first request for enforcement for Wind 1 was made, the turbine had been up and operating for several months. At the time the first request for enforcement could have been made for Wind 2, Wind 2 wasn't up yet. The funding sources, while somewhat committed, had not been finalized. And the town may have taken a second look at it, but more importantly, the funding sources may have said, you have to get this straightened out. So it is very likely that there would have been some additional hitting of the pause button then. Can I tell you for sure that that would have happened? Absolutely not. The one thing that would have happened, though, is that we would not be here tonight discussing this issue, because the appeals would have likely been consolidated both before this board, before the Superior Court, and before the appeals court, had even a remotely timely application been made, and the courts would have consolidated those cases. And I think that by not doing it, the town, to some extent, was lulled into believing that the issues with Wind 2 were far less than the issues with Wind 1. And they knew, obviously, that the wind opponents, the same litigants we have on both of these cases, were represented by counsel, very able counsel, and yet no Wind 2 appeal was taken. And I would submit that the town was prejudiced in many ways, least of, and again, the selectmen, this is a very public process. It could have turned out very differently had that appeal been taken.
Okay, last question, and it's probably the $1 million question.
Oh,
If we buy into this, and I understand this, that there are certain time requirements. So if we say we agree with you, does the town apply for a special permit for Wind 2?
I was going to answer this question as part of the opening of my, or at least attempt to answer it as part of my opening on the Wind 2 special permit. I don't disagree with certain of the things that Attorney Senni and Watt have said in that these turbines are obviously related projects. At the moment, the town has only applied for a special permit for Wind 1 because that is what the court has told us we need to do. However, what we hope to convince this board is that the permit on Wind 1 can be appropriately conditioned so as to protect any harm, real harm, to the abutters, and that those conditions will include conditions on the operation of Wind 2. And I think that although a separate special permit on Wind 2 has not been applied for, you will hear beginning tonight from Chris Menge, our acoustics expert. He has analyzed the impacts from Wind 2. And we do know what those impacts are. And we are willing to accept conditions, reasonable conditions, on the operation of Wind 2 as part of the special permit for Wind 1. And if it makes sense procedurally at some point down the line to amend our application to do that, we would do it. But again, I think that it can be, I think that you can impose conditions on Wind 2's operation as part of the Wind 1 special permit.
Okay, thank you. Attorney Dabrowski, do you have any questions?
No, I'm mindful of the fact, though, that you are going to now turn to the audience, and I just want to say to the board that comments from non-parties should be limited to one of three things, if there are any further comments yet to come. I know Mr. Anderson is waiting out there, and he certainly should be allotted his 2 minutes. Everybody else can only offer one of three things here. Either the parties knew or should have known within 30 days. They told me that they knew of the permit and they rested on their rights. They deliberately waited and thus it is or it is not latches. And then lastly, balancing of the equities. The equities go to Mr. Senni's clients, Mr. Watt's clients, and to the town. So everybody else's comments on that are largely speculative. And there will be an abundant chance to make those comments during the special permit proceeding.
Yes. So with that said, Mr. McNamara.
Thank you, Matt McNamara, 13 Vineyard Street in East Falmouth. Did you know that just after Labor Day, the building permit for Wind 3 issued? Probably not, and I hope not, but after all, I don't know because there's been a lot of construction activity at the wastewater treatment plant. Ms. Tillotson would have you believe that because Wind 1 was named Wind 1 rather than Falmouth 1, the abutters should have expected there to be a Wind 2 and would therefore put on constructive notice. She also said that because once the foundation or the pad was poured, that was constructive notice. But unless anyone has actually gone down and inspected the wastewater treatment plant on a daily basis, given all of the truck and construction activity that's been going on since that plant was built in the 80s, you would not have known necessarily that Win 2 was being built. In fact, later Ms. Tillotson said that you wouldn't have known that Win 2 was constructed because it couldn't be seen within the 30-day period. So if we bypass all of that and we get to the fact that there was no contention that there was actual notice, and I'll come back to that, was there any constructive notice? Not basically until, in my view, the turbine was actually erected, and that might have been an important time. So no duty to inquire because there was no real constructive notice up until that point. So I've got this wonderful matter about latches. And as you read through all of the case law, you can distinguish the case law. You don't have to be an attorney to do that, but attorneys certainly make it sound a little bit more interesting. Let's take a latches case and put it into layman's terms. You own a house, and there's a vacant lot next door to you. And all of a sudden you come home one day, and there's a foundation that's poured. Do you wait, and you think perhaps that the foundation might be too close to the lot line? Not that your new neighbors might be too noisy, but that it might be a zoning violation. Do you wait until that entire house is built? It's after the 30 days. And therefore, remember the two balancing factors of latches, and that's unreasonable delay and prejudice to a party. If you wait till the house is completely constructed and there's a question of whether or not that person has to take the house down, that was prejudice to that party. Now, you've heard that the issue could be loss of revenue, etc. That's use after the fact. I don't want to speculate what the town might have done differently. Remember that there wasn't real constructive notice until the turbine was erected. So where's the prejudice? Now, the question about whether or not there should have been a delay waiting for the court decision. Attorneys Senni and Watt have said, we wanted to wait till after the court decision. Now the town says that shouldn't happen. Yet look at the decision by the building commissioner in this very appeal. And the building commissioner says, I'm not going to act on this until a decision by a court of competent jurisdiction. It shouldn't work one way for the town and not the same way for the applicants. Remember that no matter how you look at the case law, the courts are trying to come to an equitable result. Now, if none of that's persuasive at all, I hope the next part is. Latches cannot be used to say, I had a right, or I had a requirement to notify, actually provide notice to abutters, but I raised latches as an excuse later on. Chapter 2.7 of the Code of Falmouth requires the Board of Selectmen to hold a hearing on all public projects that are constructed on town land. They're required to hold a hearing. Now, the town in the past has somewhat confused the difference between hearing and public meeting. It's a hearing. You're used to hearings. Interestingly enough, Chapter 207 of the Code of Falmouth requires the very same notice that you require as a zoning board of appeals. If that hearing and notice had taken place, there would have been actual notice to the Okagawas, etc., that there was going to be Win 2. We wouldn't have to be worried about constructive notice. I don't think it's equitable for the town now to raise latches when they had an affirmative duty to provide actual notice and failed.
Thank you, Mr. McNamara. Anyone else? Mr. Anderson, did you want? the opportunity to speak, or are you satisfied? I know that you had said earlier you might speak. Anyone else?
Question.
Yeah, good. Please,
Like I
if you're,
said,
if you're,
it's only speaking, but it's a term of equity.
if you're,
I don't know what
excuse
that
me,
means.
sir, if you're going to be speaking, you need to state your name, provide your address, and we'll get your question answered. Thank you.
I'm John Tudor. I'm a retired family doctor. I live in Precinct 8, 161 Conomet Circle. I want to ask the question of whether I have standing, because I don't know what he meant by the word equities.
Who?
The third category that we could testify about. What I would like to testify about is the letter you got from the Board of Health about the changes in definition of medical.
I believe that was with the special permit application, and so you will have an opportunity to speak as to that later. Anyone else short 2 minutes, since I've been going over that?
My name is Catherine Elder, and I'm represented by Attorney Seni. I live at 161 Blacksmith Shop Road. It occurred to me throughout this discussion that I might actually, or my husband and I might actually want to bring the issue of special permit of Win 2 forward now, because for the first time ever, I realized with Win 1 off all the time, that Win 2 has an effect on me, and I've never been able to distinguish that before because it's never been running without Win 1 on for any period of time that was noticeable to me. So I'm making the point that it wasn't until recently, when Win 1 was off, that I could distinguish between Win 2 and Win 1 effects. So I'm still within my 6-year statutory situation there with bringing the issue forward. And I would ask, couldn't I do that at this point, now that I realize that it isn't part of what is being required for Win 1? I mean, I just assume that if Win 1 has to have a permit, so does Win 2. Are you? My question is, am I outside of my right to bring that now?
I think that's something that you could ask your attorney. We're not here to answer legal questions. We're here to receive your questions and your comments.
Well, I think it's reasonable to understand that I thought whatever was going to happen with Win 1 would be applied to Win 2. And I just think it's disingenuous that they should be treated differently. They're both on the same parcel.
The town of Falmouth has applied for Win 1 for a special permit. That's what this board is considering. We're also considering the appeals at this time. That's all that's before us.
Right. I'd just like to say, my final comment is that if you don't order a cease and desist of Win 2, I don't know as the town is going to file a permit for Win 2. And I think that needs to happen.
Thank you. Anyone else? A couple minutes, sir? Again, just a couple of minutes.
Hi, thank you. I'm Ron Swag. I live at 8 Bay Road in Precinct 1. And I was just wondering, I heard this evening, I'm generally often surprised by what I hear, but I just heard this evening from Attorney Watt that as far as Win 1 is concerned, that it reverts back to the 69-15 Elder et al. Case before you. But I didn't hear him say that on September 17th when that was brought up about the August 20th decision about cease and desist on Win 1, which basically voted 4-0 by your board not to take up to deny the cease and desist request at that time. So I'm wondering now if whether Win 1 and Win 2 would be under this consideration. That's one factor, because we've had 2 decisions by your board, one denying the cease and desist and one supporting it. So I'm just trying to figure out, that's up to you to figure out that factor, where we stand, because it's been going back and forth and we're in a new place now. The second thing I'd like to talk about is the proponent for 6815. We've heard from Attorney Tillotson that in 2013 there was an offer made to the proponent, and that offer was not accepted by the proponent, but a counteroffer was made to the town of Falmouth, and the town of Falmouth accepted that counteroffer. And so
I just want to,
Yeah.
I don't want to necessarily go down that road again. We've been there.
Right.
As Attorney Bobrowski said, testimony now for this 2 minutes should be whether you knew, whether the appellants here knew or should have known, whether latches applies, or as to the equities. I just don't think that that's probative to anyone here. It's not going to help the situation. So testimony as to those things, and it's already been nearly 2 minutes, so I would just limit caution,
Thank you. Okay. No, I appreciate that. I'm just trying to understand why the 6815 was even filed when the town made an offer to settle the situation.
Because Mr. Anderson has a right to file 6815. That's the answer, sir.
Right. No,
that's the answer.
No, it's fine. You can file it. Exactly. But in April of 2013, he commented that he would be happy to move, but no one would buy his house. So I'm just trying to say that is the factor.
Thank you. Just a couple, and again, just to what we've had this limited to, please. Because everybody will have a chance to speak to the special permit, so the issue is the appeal.
Richard Latimer, Precinct 1. I am a lawyer, but I do not practice land use law, but I do understand the principle of laches. We initially told by counsel for the applicants here that it's either 30 days or 6 years under the principle of laches. I think Ms. Tillotson corrected that very clearly, that 6 years is an outside limit. The standard is a reasonable time, up to 6 years. So the question here is on the question of laches, whether there has been a reasonable action by these applicants after having reasonable notice. Now, as Ms. Tillotson has pointed out, the authorization for construction of Wing 2 was voted on at town meeting, well before any construction even began. These people are complaining that they can hear or feel infrasound. Couldn't they hear the noise of the excavators, the concrete trucks going on after having actual notice that this project was going to go forward? I suggest their failure to take any earlier action under the principle of laches precludes them because they lacked due diligence in protecting their rights. Due diligence would have told me, having known that the town has authorized the construction, such a major construction, and then living that close that I can hear infrasound. I'm hearing the trucks, I'm hearing the heavy equipment, and I don't go and look. I'd say this application should be denied the principle of laches. Thank you.
Mr. Latimer, I have a question for you. You don't live near these wind turbines, do you?
Excuse me?
You don't live near the wind turbines? You're not affected by them?
Are we going to, no.
I'm asking you a question, sir. I'm allowed to ask you a question.
No, I thought we were limited to laches. I'll talk about that issue.
No, I'm just, sir, I am asking the questions now. You're there, you're standing there. I have a question for you.
Yeah.
You said that if you were in their position...
I didn't say if I was...
No, you said if you were there, you would, if you think that if you heard the noises, the construction equipment...
I'm saying...
I'm not here to get into an argument, sir. Yes or no? Do you live near the wind turbines? I do not live there. Thank you. That's all, sir.
Well, no, I haven't given up...
That is all. There is a police officer outside. That is all. Thank you. Mr. Anderson.
Thank you, Neil Anderson, Flat from the Shop Road. So I'll take a breath. Okay. I wasn't going to repeat this because I did say it specifically last meeting, that yes, Wind 2 does affect me, not as much as Wind 1. The same topography and the same prevailing winds bring the same low-frequency sound right through the valley, right to our house. Regarding complaints, I also said this last time, I gave up filing formal complaints on the wind turbines. As a matter of fact, on anything, I can't make a complaint about anything now, because I'm the complainer. But Mr. Gore informed me directly that he's not going to do anything with my complaints why bother? Regarding the settlement, I submitted to this board one piece of paper, which is all I'll say. So, thank you.
Thank you. I think this is probably a good place to end. So, I think we've received all public comment, testimony, and we should have a motion to close so that we can take no more public comment, and if anybody has a motion to that effect.
Motion to close.
Okay.
Second.
Okay, so that was Paul and Ed, and that is as to both, I just want to make sure, both applications 6815 and 7015, is that?
Yes.
Yeah.
Okay. So all those in favor?
Aye.
Aye. Unanimous, and I believe we're going to be deliberating this at,
I remind the board that the decision is due at the town clerk's office on December 23rd. We'll deliberate between now and then.
thank you. So we'll take a short break before the special permit.